and I did officially break my right wrist.
What hospital was that, Ms. Woods?
Texas Health Presbyterian.
Okay, could you tell us what your outstanding bill from Texas Health Presbyterian is?
Yes, Texas Health was $3,000, $852.95.
Okay. Now, did you receive any medical treatment after the hospital?
Yes, I did. I was also at Greater Dallas Orthopedics, and that's where I got more X-rays and my cast and all of my physical therapy.
And what's the outstanding bill for Greater Dallas Orthopedics?
That was $1,214.
Okay, so that brings the total to $5,066.95.
Correct.
Okay. Have you received any further medical treatment?
No, not necessarily. I've no further medical treatment. No.
Okay. What sort of issues do you still deal with to this day?
I've just been having a lot of anxiety when I drive. It's very scary for me because when you're just relaxing and driving and like normal, and then someone just kind of hits you out of nowhere. It's just something that lingers with you, especially since my daughter was in the car with me. So I do have a lot of fear when I drive now. Every time I go through a light, it's like it just kind of hits me again, like it's going to happen. And so that's definitely something that has lingered on for me and has been really difficult to live with, to be perfectly honest. So it's been tough.
As far as where this accident occurred, how close did it occur to your house?
It was about a mile from my house. It was right outside of my neighborhood.
So do you feel comfortable even on the roads in your neighborhood?
No, I mean, it's everywhere. It's right. There's this one turn that's right outside of my neighborhood, and I still just get that flashback sometimes, and it's really scary for me, for sure.
Could you please explain to the court any kind of scarring that you're left with?
Yeah, I have a pretty nasty scar on my finger still from where the steering wheel kind of slashed it open, and there's a lot of cartilage there, and it's it's a pretty nasty one.
Okay, well, thank you, Ms. Woods. Your Honor, at this time, I'd like to go ahead and enter judgment against
request judgment. Do you want to request judgment?
request judgment on damages against the defendants.
Okay. What are you requesting in terms of damages?
So
what are the total medicals?
Requesting past medicals, total medicals of $5,066.95.
Okay.
And
past pain and suffering.
Past pain and suffering in the amount of $30,000.
Okay.
And then future pain and suffering, mental anguish in the amount of $80,000.
80,000. Okay. All right. I didn't really hear anything on the future. I'll grant the past, and I'll grant. Ma'am, are you still having problems with your wrist?
No, not necessarily.
What about mental anguish? Are you still having mental anguish?
Yes, absolutely.
Okay. So I'll do future mental anguish, let's say $20,000, and past mental anguish, $20,000. All right. And go ahead and submit a judgment on that. Make sure that you say that this is an amended final judgment. That there was a hearing on, also include at the beginning, there was a hearing on damages on April 29th of 2024. And I would suggest you get that in this week, because there might be an issue of plenary jurisdiction if you wait too long, because there's technically a final judgment that had been entered at your request. So I would try to get that judgment in this week, if not today.
I'll file it immediately, Your Honor.
All right, and when you e-file it and also email it to my court coordinator.
What email would that be?
It's on the website, but Rhonda, if you want to give it to him.
Yes, it's Rhonda, RHONDA .Pinson, P as in Paul, INSON at dallascounty.org. And that email again is Rhonda.Pinson at dallascounty.org. And Dallas County is spelled out.
Thank you, Ms. Pinson. Thank you, Your Honor. I appreciate y'all's time.
Ms. Woods, I wish you the very best of luck. I hope your injuries recover soon, and you guys have a great rest of your day, okay?
You do the
Thank
same.
you.
Thank you, guys.
Okay.
Ms. Nguyen, did you find out that information, or are you still looking?
I found that information, Your Honor.
All right, give me what's the case number on this one again?
Case number for Wells Fargo Bank versus Ryan Gilliam is DC 2311842.
You got that one, Rhonda?
Yes.
Okay. What's going on?
Well, Your Honor, it seems like can't find him. They have been running skip traces since that return of non-service that was filed back in August of 2023. Even his driver's license hasn't been renewed since 2022, and it still reflects that same Cedar Springs address that was on the return of non-service. Plaintiff has been diligently trying to prosecute, trying to find to serve, but they're just asking for more time for that service, Jeff.
What are they going to do to try to get? I mean, what other avenues, I guess, are they looking at?
Well, when I was on the phone, they were actually running another skip trace again to see if they can find new information based on employment or based on any of the information that they have on the other reports. And they're waiting for that result.
All right, Rhonda, go ahead and reset this one for 2 weeks. We need to get a subservice on file within 2 weeks, or we're going to de-wop it.
Thank you, Your Honor.
All right, you have a great rest of your day. Anyone else here on the dismissal docket? All right, let's move to the hearing docket. Rhonda, so in this Benz versus Martin's case, it's the first case on the docket. They said they just filed a proposed final judgment. I'll go ahead and sign that, and I'm gonna put it in my queue right now to sign, and we will go from there. All right, next case on the docket is DeMarcus McFarland versus Harris. Anyone here in that case?
Tanner Foreman, Your Honor, here on behalf of the plaintiff.
John Ledger, Your Honor, on behalf of the defendants.
All right, Tony, let's go on the record on DC 2316693, McFarland versus Harris. Counsel, make your appearances.
Tanner Foreman on behalf of the plaintiff, DeMarcus McFarland.
Your Honor, John Ledger on behalf of Reggie Earl Harris, DBA Harris Trucking, and Dustin Wayne Kiefer.
All right, let's proceed.
Your Honor, John Ledger here. We are the movement in this particular motion. It's a motion to have an IME appointed on the plaintiff. This accident, and I apologize, my voice is very scratchy. This particular case involves a motor vehicle accident. Mr. Foreman is the opposing counsel in this case, and our two respective clients dispute or disagree on the actual cause of the accident. But probably the simplest way to put it, it's a more or less a simple sideswipe type of accident. Exhibit 1 to my motion, Your Honor, I've attached a couple of photographs of the plaintiff's vehicle, showing that it's a sideswipe, and and a fairly minor accident as far as the vehicle property damage goes. And that's exhibit 1 to my motion. Exhibit number 2, Your Honor, to my motion is an interrogatory response to interrogatory number 9. I put the verbiage of that response into my motion where the plaintiff himself is claiming that he sustained a traumatic brain injury in this accident. And I'm just going to read what he states. I sustained a traumatic brain injury that continues to cause dizziness, blurred vision, forgetfulness, sensitivity to bright lights. The traumatic brain injury I sustained has profoundly altered my life, particularly my mental health and communication abilities, lack of confidence in my mind and memory. I experienced long, dark periods in disoriented head pain after the accident. Each conversation seems to be off in an unknown way. Words and thoughts were not focused on what was happening in real time, along with random images of people.
I've read this. So let me ask you this. So I guess my question is the defendant, or sorry, the plaintiff is arguing, respondent is arguing that there's less intrusive ways to get to the information he wants. It's the deposition of treating doctors. They rely on NRA HEB Grocery Company, LP, NRA Caballero, NRA Ruben Gonzalez. How do you have you taken the plaintiff's treating physician deposition?
I have not taken the treating physician's deposition yet, Your Honor.
And why wouldn't you do that first before you request an IME?
I don't think the HEB case actually requires that I do that first, Your Honor. The plaintiff has put their own medical and mental condition, at the forefront of this case. And if you read the HEB case, it says, Supreme Court states that negligent plaintiff who asserts a mental or physical injury places that mental or physical injury clearly in controversy and provides the defendant with good cause for an examination to determine the existence and extent.
So you're arguing the HEB case says that in every personal injury case, an IME would be allowable?
When there's going to be a controverting evidence presented by the plaintiff, yes, Your Honor, absolutely.
So that would be every case, right?
That'll be every case.
Okay, and that's what HEB says?
I believe it does.
All right, go ahead and share screen that case of the area you're talking about.
I don't have it saved, Your Honor, to where I can do that.
Mr. Foreman, can you share
I haven't
screen?
attached my motion.
You said you have it attached to your motion, that case?
Yeah. And if the plaintiff is going to make a traumatic brain injury claim at trial, then I think the defendants have the right, according to the HEB case, to present evidence otherwise. And the only way you can do that is through this neuropsychological type of examination. Otherwise, the defense can't present any evidence of that. And
I'm not necessarily disagreeing with you. I'm just saying there's cases that say.
Stipulate, Your Honor, in this hearing today, that they're not going to claim a traumatic brain injury claim, then fine, this issue is moot. But the only way to get this information is through a neuropsychological exam.
So in HEB, let me go ahead and share screen those, because I think this is kind of the key point. All right, can you all see that okay?
Yes.
Finally, HEB has shown that the desired information cannot be obtained by less intrusive means. Although Dr. Swan has reviewed Rodriguez's medical records, he explained in his deposition why a treating doctor is in a better position to examine and treat a patient's injuries than a records review doctor. Significantly, Rodriguez intends to prove causation and damages through expert testimony, and Rodriguez's expert has already examined him. HEB merely seeks to allow its competing expert the same opportunity, and the results of Dr. Swan's request examination go to the heart of HEB's defense strategy. I mean, but none of that's happened in this case. There hasn't been any type of affidavit or deposition or taken. I mean, I just feel like we may eventually get there. I just don't know we're there under HEB or any of the progeny. In fact, I think I could be reversed if I did it this quickly, right?
I don't believe so. That what you read, a treating doctor, he's currently being treated for this.
Yeah, but I
And
don't have any evidence in this case that your expert has even reviewed any medical records. He hasn't been deposed. The other side hasn't been deposed. I don't know what the other side, I mean, I don't have a record before me on this. That's what my point is that
if
there's
the court were to see an affidavit from Dr. Bariza that he's reviewed the plaintiff's medical records, would that be sufficient to the court?
not possibly, it's just not what I have in front of me today.
Well,
Let
I'm
me hear
happy
from
to
Mr.
present an amended motion to the court, but I would like, if I can, get an understanding of what would satisfy the court. And the court's mentioned that they haven't seen anything that Dr. Bariza has reviewed any medical records from the plaintiff. If I provide that evidence to the court, will that be sufficient?
And I answered possibly. I don't know. I can't make an advisory ruling. I don't have the record in front of me. I don't know exactly what he's going to say. I'm going to follow the law. I just don't think there's a record before me right now. But let me hear from Mr. Foreman.
Sure, Your Honor. Rule 204 makes it perfectly clear that for an IME, there needs to be good cause, and they've cited what needs to be good cause, and that is that it's not possible to obtain the desired information through means that are less intrusive. Again, they haven't taken the plaintiff's deposition. They haven't deposed any of plaintiff's treating providers. As far as we know, their expert hasn't even reviewed any of the medical records. And so at this juncture, they're unable to show that there's not less intrusive means to do it. On top of that, the examination that they're asking for, Your Honor, is with a neuropsychologist. They're asking for 7 hours of testing with any number of 28 tests. The plaintiff has not seen a neuropsychologist in this case. He has not undergone neuropsychological testing. So they're asking, really the purpose of an IME is to put the defendant or whoever else it is on an equal footing. They're not asking for equal footing here. They're asking for our guy to go and get evidence that currently is in existence. And for those reasons,
Has your client seen a neurologist, or who has diagnosed this?
He has seen a neurologist, but not a neuropsychologist.
Yeah, I would tend to think, that's interesting. I don't think I've ever had a case where someone's requested an IME from a different type of doctor. So it would probably need to be a neurologist in this case, although that's not a final ruling. That would be usually in this situation what I've seen before. I've granted IMEs before, is that there's been a neuropsychological test, then there's a neuropsychological test, and then the neuropsychologist for the other side says, hey, I've looked at this and I need this additional testing because I can't tell from this testing X, Y, and Z. But we haven't even had neuropsychological testing from the plaintiff. So my gut instinct is that I wouldn't allow a neuropsychological exam, especially not a 7-hour one. That's possibly the neurologist diagnosed a traumatic brain injury, I guess.
That's correct, Your Honor.
And what recommendations is he made?
He made a number of recommendations. The issue in this case is that the plaintiff is a retired veteran, and so he's also being seen at the VA for a lot of the same issues. I know that he did undergo some speech therapy. I think he did have a couple of other therapies, but those are the basic recommendations that have been made to him.
The neurologist recommended speech therapy as a result of this accident.
That may have been somebody at the VA, and I'm not sure if it was a neurologist at the VA, Your Honor. I apologize.
Okay. Anything else today, guys?
Well, the neurologist that plaintiff is seeing, see, the plaintiff has allegedly serious PTSD, and that needs to be sliced through to determine, okay, what is PTSD related to his military service, and what, cognitive issues or deficits he have related to this accident itself. Now, what's going to happen is plaintiff's going to get a neuropsychologist. They're going to do a battery of exams, and they're going to designate their expert designations. And then I'm going to have no time. I'll be back before the court with a motion to continue, which I'll be entitled to, because we won't have time to come to the court and have a motion to compel an IME. The only way to get the IME results is through a neuropsychological exam. It's the only way to get them. And the plaintiff himself has made these serious claims. I don't even think the plaintiff's neurologist has diagnosed him with the claims that he's made. The plaintiff has diagnosed himself. Now, clearly, he must have PTSD related to his military service.
I
But
mean,
if the court wishes, I'll
you-
entertain this motion another time. But I don't think the HEB case requires me to do so.
Okay. Anything else today, guys?
Nothing from plaintiff, Your Honor.
All right, you guys, as things develop, when is your trial setting on this? You're set for a non-jury trial on December 17th, just FYI.
Okay.
All right. Anything else today, guys?
No.
You guys have a great rest of your day, okay?
Thank you, Your Honor.
All right, next case is there anyone here on the Wallace case, DC 219146668?
Yes, Your Honor. Sean Wallace on behalf of plaintiff Jason Wallace.
All right, so this side here.
Not that I'm aware of, Your Honor.
Okay. All right. Tony, are you ready? Tony, are you ready?
Ready, Judge.
All right, let's go on the record on DC 1914668, Wallace versus Peru Properties LLC. Counsel, make your appearance.
Sean Wallace on behalf of plaintiff Jason Wallace.
All right, make your argument.
Thank you, Judge. This is a motion to compel post-judgment discovery, responses and depositions, and a motion for expenses. My client served post-judgment discovery requests on plaintiffs on December 11th of 2023. A copy of those interrogatories and requests for production are attached to the motion. Responses were due on January 10th, 2024, and to date, defendants have not served any objections or responses to the discovery, nor have they produced any documents. We also served notices to take the depositions of plaintiffs. A copy of the notices are also attached to the motion as Exhibit B. Defendants were required to appear for depositions at 9 a.m., 11 a.m., and 1 p.m. on January 23rd, and they did not appear. A copy of the certificates of non-appearance for defendants are attached as Exhibit C. And then an affidavit of Paige Megacy regarding defendants Ali Rizvi and Nasir Rizvi their failure to appear at their depositions is attached as Exhibit D. And then a copy of the affidavit of Kurt Covington related to fees and expenses and our preparation of the motion and attending for deposition is attached to Exhibit E. We ask that the court compel the discovery responses and the production of documents without objection from plaintiffs as they missed their deadline. And we ask the court to compel their appearance at deposition.
So I've already ordered them to appear at a deposition once. Is that right?
I don't believe so.
Okay. I meant maybe what did I order before? You said I made an order before.
No, I don't think you've made any order before.
Oh, I'm sorry. I misunderstood you then. Okay. All right. I will grant that. So you noticed it, but they didn't show up. That was what happened, right?
Correct. Yes, Your Honor.
Okay. Give me 1 second to get to your order. All right, this is on Wallace versus Omnibuild, right? Let me just take a look at this.
Yes, Your Honor.
Requesting $2,356.50 in sanctions. Is that correct?
Yes, Your Honor.
All righty, I've granted that.
Thank you, Your Honor.
Anything else today?
That's it for today.
All righty. You have a great rest of your day.
You as well. Thank you, Your Honor.
Mr. Mathis, what are you here for today?
Good morning, Judge Hoffman. Your Honor, we have a case on tomorrow's non-jury docket, and I didn't get the
Yeah, I'm
email
excited to try it. We haven't tried one of these in a while.
Judge, and defense counsel is I think she has a hearing in Fort Worth, Your Honor. So we didn't know if we needed to appear this morning for the docket this morning, Judge. Or do we just need to show up tomorrow ready to go, or?
Yeah, I'm sorry, I don't understand you.
I'm sorry, Judge. So we're set for tomorrow for non-jury. We didn't know if we needed to. I told defense counsel, and I could be wrong, I thought we needed to appear on Monday for scheduling, or
No. I'm sorry. I don't know who told you that. I hope was that my former coordinator. Okay. You just show up on the day of trial. I'm pretty flexible about non-jury trials. If both sides agree, I'm going to do whatever. I allow you to appear via Zoom if it's allowed by law. So if the other side objects, that may be a little more complicated. But if you guys just want to appear on Zoom, that's fine. How long do you think this would take to try this case?
Your Honor, at the most 2 hours, and more likely an hour and a half.
So just, in full transparency, we have a case ahead of you that's a one-day jury trial. So there's a decent chance we'll kick you to Wednesday.
Okay.
And if that case goes away, then I think you're the next one up. So
okay, sounds good, Your Honor. We'll keep Ms. Pinson informed on all matters.
But it sounds like it's ready to go.
It is.
And I'll you can show in person or on Zoom unless the other side objects.
Okay, sounds good, Judge. Thank you.
I'll see you tomorrow.
You too. Have a good day. Thank you.